get started, and hopefully we'll have some more good time. Happy New Year, everybody. Happy New Year. Is 2016 going to be a great year? Yes. Yes, it's going to be phenomenal. And that's because you are going to reach heights you never thought possible. How many of you are new to real estate? Okay, we got a lot of new individuals. For those of you who are not new, I want you to write down right now the 3 biggest issues you had with your transactions in 2015. And then I'm going to ask you to share them with me so that we can talk about it, so that you as new agents doing transactions won't have the same problems, and we can kind of brainstorm a little bit. And these would be problems other than your buyers and sellers' personalities. I'm talking about for the transaction, what was it that came up that caused a conflict that had an issue for you? Okay, somebody share with me what you wrote down. The first one.
Inspections where the seller does not want to do any repairs.
Okay. As a buyer's agent, we wear 2 hats all the time. Sometimes we wear a buyer's hat, and sometimes we wear a listing agent's hat. So I'm going to talk to you from a perspective of how you should coach your buyers better, and visit with them regarding the documents that you always have inside before you start showing the property. As a buyer's agent, the buyer had to know at no time is the seller ever required to say yes, ever, okay? Once the parties have an executed contract, the seller doesn't have a provision to terminate. In other words, they couldn't say to the buyer, I'm not going to make these repairs, I'm terminating. A no seller can ever terminate a contract. But what they can do is tell the buyer no. And I think what we are afraid to do, and Trek has confirmed this in their statistics, they find that agents, in the course of assisting their buyers and sellers in transactions, they never talk about what will happen if that party says no, or in the event this happens, you could lose your earnest money, or something could go wrong. We just are not bent on bringing that to everybody's attention when we're all supposed to be excited about making an offer on a property. It's that great balance that we have to have. And unfortunately for a buyer, they know that when they put in an offer and it's accepted by the seller, there are provisions in the contract which will guide them for the rest of the remainder of the transaction until it closes in funds. And there's a process, Happy New Year, that you have to go through. And when a buyer says, I want the following things done, and the seller says no, that's the point in time where a buyer has to make a decision. Well, do I terminate for my unrestricted right to terminate and get my earnest money back? Or do I stay in the transaction, accept the property as it is with all of its faults, and go forward? But I think the problem is that as buyer's agents, we don't tell the buyers that the seller actually gets to say no. I do. Yeah. That would be, it is so important, as I said, because expectations, this is all about us setting proper expectations. And if I'm a buyer's agent, I'm not going to be Debbie Downer, but I certainly am going to make sure that the buyer does not have unrealistic expectations. And particularly the first thing out of the chute I can think of is my performance, my availability, what my duties are to them. Because a lot of times buyers tend to think, if I snap my fingers, you have to appear. Don't you? Well, I have been involved in a lot of Trek complaints with the various brokerages, and it was interesting. We had one many years ago where the buyer contacted a buyer agent on a Sunday and said, I'm in front of this house, I want to see it. Have you ever imagined, oh yeah, honey, I had lots of buyers like that. And you're going, but I'm already committed to either showing somebody else or another commitment. We have a life. And this gentleman, this young man said, well, I'm out on my ranch, my mom and dad's ranch, and I'm chopping wood. Let me get cleaned up, and I should be able to be over there in about 2 hours. Now, personally, where he was, I know where he lives because I live out in that area. That was a major concession on his part. And it turned out that nobody is held to jump through hoops when those kinds of calls come in. So he did extraordinary measures, and they thought that, she said that she had the right to leave their buyer tenant representation agreement because he didn't come immediately. Well, she was wrong. So that's why I'm really, the expectation level, a lot of times when buyers act a certain way and sellers act a certain way, it's not because of something maybe that you have done, but maybe that you fail to get on board and understand the expectations and communicate those well and get their consensus. In other words, getting their agreement that this is how I work. I have a lot of agents who tell me that right up front they will not work on Sunday. And in their buyer tenant agreement and in their listing agreements, the buyer and sellers have acknowledged that. Now they do tell me that if it's an emergency or something, they do respond, but they might not be letting the party know that, hey, I'm not in the office on those hours. If something does come up, I'm certainly available and that type of thing. And so you can kind of understand that was the expectation level. If somebody signs a listing agreement and you told them that, or that you won't be available after a certain hour in the evening or whatever as a rule, then they can't complain about it later. See, that's the big difference. So again, I think we have to do a better job of setting the expectation levels. And it's different when you're a new agent. You're thinking, I'm going to do whatever they want me to do. I need the business. I understand that. But as you go through and you become proficient in certain areas and you have the skills and you fine-tune your scripts that you use with them, all of a sudden you realize, hey, this is my business. This is how I want to conduct business. If you want to buy into it and work with me, that's correct. You know what I'm saying? It just changes. I had a call just on my way here. And a transaction facilitator for a very large team here in Houston. Kat called me and she said, this seller is saying things to me that are discriminatory. I said, you fire him right now. I said, you have to get in touch with the lead agent who has the listing agreement. You tell him to fire him, but it stops now. And she says, okay. So I said, it stops. When people do bad things or have bad behavior, you can't go on with it. You have to say, I'm done with you. It's not about commission at that point. You know what I'm saying? It's about doing the right thing. And she says, oh my God, she said, thank you for saying that, because she said, that's what I wanted to tell the lead agent. She said, he's scaring me. I said, he should scare you. He's scaring me. So again, we have the ability to stop certain behavior. We're not forced to be subjected to that, even if they're our client. Okay, did that answer the question about inspections? I bet so. A little bit more than we want to know. Well, Sheila, what did you write down?
Well, I had several episodes where, and this was before the new federal mandate went into effect, where we got to 3 to 4 days before closing. I represented the seller, and the buyer's lender was still not, they weren't clear to close. They still needed documents from the buyer, or something was, the lending institution was just not communicating, and it was like, who can tell me, when
The truth.
we're going to close and what the problem is?
And what she talks about has not gone away.
No.
Yeah. And I was hoping, I prayed hard. I thought maybe after October 3rd, we would have a different relationship as far as communication and understanding, because of the Trilla requirements as far as how, oh, I'm so sorry. They don't look at me. You know what's funny is I apologize. My husband used my phone yesterday to help me to reset some things, and I put it on stun, and yet he said something, and no matter what I do on the volume control, it's going off. So I apologize. He was doing his best, but what my biggest concern is about the transaction. When a seller says, yes, I accept your offer from a buyer, it's more than just looking at the net sheet. You know, they need to know, can I sell it for this? I understand the importance of a net sheet, but there are so many variables that happen through the course of the contract that could cause delays or turn the seller's life upside down when that other party hasn't responded. And again, as I said, we wear two different hats many times. You know, as a listing hat, that's one of those things. We don't have a crystal ball. We're going to take on the word of others, professionals, and particularly in the third party, that they know what their process is, their job is. We've had a lot of lenders who refuse to share the actual closing disclosures with the agents, even when the buyers have signed the mandated authorization form. They're very afraid to because of the Privacy Act. And here's what I am going to tell you. The sellers who successfully nailed buyers because their lender was poor performing were those sellers that, while the listing agent contacted the lender and visited with them and asked them questions, in fact, they asked reverse questions from my worksheet that I gave the buyer's agents to give to the buyer and the lender. They asked the reverse question, the question that would match that if I were the seller. And the listing agent reported back to the seller, and the listing agent said, you know, I had that conversation. I want you to have the conversation now. And that has made all the difference, because when the listing agent contacted the seller and said, we've just been told that the buyer's not approved, and you know, they're 3 or 4 days before closing, that seller had no problem picking up the phone and talking to somebody that they had visited with before. And that was what was interesting in 2015. There was a shift. While the listing agent had satisfied maybe what they felt was their responsibility or their due diligence, they did not let the seller release from it. Just because the agent found out doesn't mean the seller has found out. It's much like a buyer. A buyer is going to have confidences with the lender that we don't share with them. That lender has a fiduciary duty to the borrower, not to the buyer's agent. They would love for you to just stay out of it. And that's part of their language of everything's okay, everything's okay, everything's okay. And then 4 days before closing, they're not okay. It's not okay, it's not going to close, that kind of thing. But I think that's, if we can shift the dynamics. And a lot of times, it's not that you are telling the seller to do something you haven't already independently done, but those lenders say things differently to different parties. They'll talk differently to a listing agent or a buyer's agent than they will to a seller who they know their fiduciary duty to the borrower is to say good things so that the seller will accept their offer.
Right.
Yes.
And then the lender's attitude, and I called every time, I mean, I stayed on top of them, and the buyer's agent did too, but the lender's attitude was, well, we're gonna close. It just may not be one. Or, you know, we're gonna close, so it's like.
So he had a crystal ball.
Yeah, you're gonna close, but we just don't know when.
Yeah, and
Sellers moving, the movers are coming.
Oh, I know.
They'll be here for closing.
that's why I really strongly really suggest that a seller's temporary residential lease always be attached, because a few years ago we had so many problems. We had sellers suing the listing agent because they were repeating what the other parties had told them, and they're only acting on information they received. They told the seller everything's great, we're going to close on Monday. Sellers move out, and then the buyers didn't close on Monday. The lender made a mistake. You know, those types of things. And so it's, you know, they look at it very differently. And it's interesting, under the scrutiny that they are now, they have somebody who's looking over them to make sure they cross all the T's and dot all the I's. They could still care less about the agents in the transaction. And sellers need to understand that. That's why it's very critical for them to do their own independent evaluation. For instance, they say they want to terminate and not do that, if you represent that seller, you better talk to the best real estate attorney, because they're going to be subject to the federal regulations just like we are, okay? Sellers are too. That's why appraisers and sellers shouldn't get together, because you never want them to say something accidentally that an appraiser would stop the whole process. But I don't think it's going to go away. And I'm going to tell you how we can fix it. We can tell buyers that you have a list of several, 3 or more lenders, and those are lenders who have a proven track record that their process is the same every time, that they do things the right way, timeliness, and they close on time. We can stop that pretty quickly. Unfortunately, when a buyer brings their lender already into the transaction, there's nothing wrong with you saying, oh, fine, I appreciate that. Just make sure that you have established really good communication with them, and every month you must report back to me and give me the status. There are things you can make them do, because we know that when they have a relationship that's already pre-existing, they're probably not the lender's not gonna communicate to you, but be focused more on their client and their responses. But we as agents, let me tell you, we have been able to turn around most of the bad things that have happened, because our sellers will turn down offers presented with certain lenders. We've already got that. They have the right to do that. That is not discriminatory. They're not practicing discrimination because they say, I won't accept any offer from a buyer who's using a bank. That's their choice, okay? And so that's where it can stop as listing agents if we advise the sellers better and give them their choices. Now, bottom line, the seller wants to sell their home, right? So while you've said all these things to them, they're going to say, hey, but this is such a good offer, this is what we want, this is what we need. And then when things go south, you're going to, unfortunately, step back and say, remember when we had this discussion before you accepted the offer, kind of mentioned to you, and in fact, I even sent you an email that said my track record with this bank hasn't been very good because they don't respond. That'll keep you out of jail, listening. Not knowing too much on the other. Okay, share with me something else that you wrote down. I know you'll have more problems with this.
Receipts from the people that do the repair work.
Okay.
I always instruct my sellers when they have the repair work done, give them a copy of the receipt. But I like for the plumber or electrician to write down specifically what they do. They don't always do that. So when you give the receipt to the buyer's agent, they really don't know if all the work was done.
Yeah, you could never give a receipt that did not identify by line item what was negotiated on the unit. That's your job as a listing agent. So maybe what you need to do, in that addendum that I have, I say that they need to have the repairs done 15 days before closing. But maybe what you can do is give a sheet when you order the repairs. Here that we've been submitted an amendment by this buyer. The buyer is asking for X, Y, and Z. When you hire that plumber, when you hire that electrician, you're going to tell them this. Okay? That's the way as a listing agent to get that process better. My problem is that the listing agents just kind of gloss over paragraph 7 at the time the amendment is presented by the buyers. And that's the big mistake for listing agents to have done that. That would mean, hey, Mr. Seller, we have 27 items they want. I need 27 invoices. If you know what I'm saying, if you said it that way, I see what is presented, and I have these lists that are attached as exhibits to paragraph 2 of the amendment. It shows all these different repairs, and I immediately start getting scared because I don't know how anybody could supervise them. Do you know what I'm saying? Something is just, something's going to be missed. And I don't like that because you are subject to supervising it. What it means, like I said, telling them this is what you have to have on every invoice that you submit so that we can prove to the buyer that we've done that. Any other issues that you had in 2015 in transactions? Yes.
That was the title company said a notary out of their group was a third party person, and she was not willing to give the documents on a timely manner because we closed like 1 o'clock
because sometimes that's the way we have to, it's a visual type of thing, but the fact that the title company apologized, I have found more title companies apologize than lenders.
True.
Has that been your experience? Yes. And it's I'll tell you why. They're governed very heavily by the Department of Insurance. Because I've turned in complaints to the Department of Insurance regarding what title companies did. And man, that investigator, if I don't like the way the investigations go, you know how firm they can get and that kind of thing, I would be really afraid of the Department of Insurance investigators. They really come out with a fury. And so, but I have found more title companies, but that was just, you're right. They were relying upon another professional third party to send out a mobile notary who knew what they were doing. But that's unfortunate. Maybe what you can do next time, if you're ever faced with a mobile notary, you can say, okay, does this mobile notary know how to get those documents back ASAP so we can fund? That's not hard for you to be able to say that. And again, that's a shame that the title company used a vendor that wasn't very good.
I mean, it was a big apology because they said they never sent somebody like that. And it was already December 23rd, and it went on.
That's why it happened. It makes sense. It's like if they sent me out to do it.
So the next day,
You know, I'm the only one who answers their phone. Yeah, I don't do that. You know, that kind of, you laugh, but that's been the situation in my house.
yeah, but in Houston, I was surprised that FedEx was able to send the documents from Katy all the way to Woodlands in 2 hours.
I am very impressed because that's a lot of traffic. I know I drive.
And everybody was calling me because it was at 24 in the morning. We were like, oh my gosh.
That is amazing. Well, they were trying their best to make up for that.
But it was, I mean, never was a Christmas day.
No, I have closed on New Year's Eve at 10:30 at night with an escrow officer for a builder, new construction, and they had to have that unit closed. Yes. Okay. And all I know is the escrow officer was in a ball gown. And she was none too happy. I will never forget that. Now, I lost that whole day because I had been with them since 8 o'clock trying to get the superintendent to get the things changed and fixed so that we could close. You know, that was what it gave to me, but she was not very happy. It was a beautiful ball gown. I don't know. It was more than like a New Year's Eve party at somebody's house. It was a beautiful, she was probably winning an award or something because she was dressed that well. But what I wanted to share with you is that the transactions always have some kind of situation that comes up. Most of what we heard today were things that were not in our control. Some things we can probably do better, like expectation levels and giving a little cheat sheet to our sellers and saying, if you accept this commitment for all these repairs, I need 27 invoices showing every one of these changes, that kind of thing. But most of the time, we are in it and have to resolve it, but we're not going to be the party that can go out there and do it. We are the facilitators. That's really what we do between the parties, try and get communication, try and get to the bottom of it. Where exactly is it? And communication is the key. I am going to tell you, for longevity in this business, all you new agents, is return your phone calls in a timely fashion. Okay? We have found that the sooner you return those calls, especially if somebody's upset, the better it will be. They can almost forgive a lot of things because you've now been sensitive to them. You're actually responding to their needs. Okay, what we're going to do today is talk about the new provision that's in the contract regarding paragraph 7A. And 7A had a change that said that in the event a work with tenants. I want to bring some things to your attention. If you are a listing agent for leases, we're going to have a session next time talking about that and making sure that you're doing things the right way for your landlords. But today we're going to talk about the lease and the changes. Okay. Why should a hydrostatic test be performed? Well, this is where agents need to do a really good job when they show property and read everything that they have presented to them, all the associated documents that a listing agent may post. Man, you're going to pull all of that down. Because the first signal to us will be if we have noticed, even before the inspector will inspect the property, if we get notice that there has been previous foundation work done on the property, that's the first thing you're going to advise them. You're going to say, would you like me to ask the listing agent for the copy of their hydrostatic test at the time the foundation work was done? But your buyer needs to understand that test was done in the past. Unless that test is a week old, I wouldn't go with it. Do you see the difference? And so your failure as a buyer's agent is that you rely upon information that came from the past that's too old. It needs to be verified by the buyer now, maybe calling out the foundation company, calling out a structural engineer. All sorts of things need to be done. But we know a hydrostatic test should have been performed if there was ever any foundation work done on the property. That's how the sellers knew, the owners knew that the work was done well and no damage was done, okay? Again, you may receive a notice that says on the seller's disclosure, previous foundation work is marked, and in section 3 they explained that, in 2013 that foundation work, and it says transferable warranty, okay? At those points, you're gonna want copies of all of that, even before they submit their offer, because if you've downloaded and known all of that information, that buyer needs to be well informed of what am I going to have to do because I'm interested in a property that has this history. And that's the biggest thing. This hydrostatic test is exactly that. It's not an inspection, it's a test. Anytime a test is done, this is an invasive test. In other words, it goes into the property. Much like we might have them where a stucco wants to go in and drill in. That's invasive. That's going inside something to determine if there's some moisture. Same way with the mold test. All those kinds of tests cannot be done by a buyer unless they have permission from the seller to conduct those tests. Same way with the hydrostatic test. Now, I am going to tell you that once you explain why, the inspector should always know anything about the property that the buyer and you know, okay? If you are going to tell the buyer, look, share this inspection report or bring it to the inspector's attention, they had foundation work done in 2013, and here's a copy of the piers that were done. While the inspector is not a foundation individual, they don't need to have it hidden from them. And I know they can usually see it because they notated, they can tell where there was previous piers put in and concrete was done. But don't ever feel that the inspector should not go to the property knowing everything that you and the buyer know about the property. That's the best way to do. Because a lot of times they're going to take a little bit more time to look at something because it's been brought to their attention. Inspectors are just like us, they're human, and they, from time to time, they might overlook something. But again, it wasn't intentional, but I think we have to be purposeful here is what I'm trying to tell you. We need to be purposeful in telling the buyer, this is what you need to let the inspector know, okay? They're the ones who are making the commitment to choose that inspector and facilitate the time. And then just remember, as the buyer's agent, you must tell the listing agent, we have a truck inspector coming at 9 o'clock on Tuesday, January 12th. His name is John Doe, okay? And most of us know the inspectors that have been around a long time, so we kind of know if that name doesn't sound familiar, you're going to go out the truck and see if they are active and that type of thing. Yes, do you have a question?
Yeah. When you get a house and you show it to your buyer and it's let's say it's a house that has previous foundation work and it's got a lifetime warranty and whatever, are we required to verify that?
You are to bring it to their attention, tell them we need to request the transferable warranty, and the buyer needs to verify all of that during their option period.
The buyer?
Yeah.
So it's not really our responsibility.
It is your
we can make it-
responsibility to advise them to do it,
Right.
but you don't have to independently do it. If you choose to do it, you better do a perfect job.
Right.
Just so I just want you to be sure, because anytime we say, don't worry, I'll take care of that, you know what I'm saying? You really are. You've already committed yourself to making sure it's perfect, you know? As I said, once we know as an agent that a buyer is excited about this property, you really want them to run from it, you're gonna make sure that you're gonna be very careful and dutiful about a list of what you're presenting them, that you've reviewed it with them. Because when we know that the property has had issues, those sometimes don't go away, they can get worse. All of our lawsuits about foundation work, the buyer agent failed to tell the buyer they need to hire a structural engineer to come out and see if the work that was done 5 years ago, 2 years ago, 3 years ago was done right. They all got nailed. You know, that's just common sense. Would you buy a property without checking that out? You're an agent. Absolutely not. Would you believe everything the seller wrote on the seller's disclosure? Absolutely not. You know, because we know through our experience. So if you wouldn't do that, why would you have somebody you represent? So again, that be mindful of that. I hope your little one is better, you're feeling better. Yeah. Okay. The next one is, when should the test be performed? Well, it's interesting. This form had probably 11 hours of discussion with an attorney. And the attorney found out a lot more about hydrostatic tests than they ever wanted to know. Okay? So it's kind of interesting because until you've been witness to it or you've been through it before, you really don't know what it is. And no seller probably knows. Most buyers probably don't know, to be honest. But what the attorney was very concerned is that he wanted to make sure that if you have a buyer who has been told by their inspector or by your experience that they need to have a hydrostatic test, that they in fact conduct that during their option period. So if you have to extend the option period, you'll do it. On that, you'll make sure that the results of the hydrostatic test, and usually I'm going to tell you the results right away, and I tried to explain that to him, but he said, well, we want to make sure that the results are in writing. And I said, okay. So that those results will also be given to the buyer during the option period, so that that buyer has the unrestricted right to terminate. That was the biggest thing the attorney was more worried about. What would happen to this buyer and seller if you did it outside of the option period? What happens then? And so just remember that it can only be conducted during the termination option period. That's the best way for both parties, for the seller and the buyer. You don't want your seller to be trapped having to make a decision about something and feeling pressed because they have maybe gone outside of the option and gone farther into the transaction. So just remember that, yes.
So let's say that you recommend it to your buyer, they have it done, and it damages the seller's property. Who's responsible?
There's this addendum that we're going to go through. That's okay. That was our concern. There are some general counsels for other brokerages that have a form, but they don't include the listing agent and the listing broker. Well, I don't know any listing agent or broker that would ever have their seller sign something that says, if you can't sue any of them, but come after me. So that's how I approached it with the attorney. I said, you know, I know how these offices are. They're not looking at a cooperative nature. And you know how I talk about cooperation. We need to be cooperative. And my concern would be the actions as a result of trying to get this authorization could cause World War III. And that's not in the best interest of our clients. Either you're a listing agent or a buyer's agent. We really want to make this process a process that's not going to cause big concern and conflict among the parties, much less pulling us in. says, how? Here's the form. Everybody's got the form? Okay. This addendum will be a part of the sales contract. That was the biggest thing, is the attorney was saying, you have to have an amendment to the contract, and then you're going to add this addendum to paragraph 22. Paragraph 22 in the contract is where we notate all the addendums that are added to the contract. And the reason he said that is because I'd asked him, I said, look, if we just have a plain piece of paper that doesn't relate back to the contract, what is that going to do if there's a conflict among the parties? He said, okay, I understand what you mean. I said, I'm telling the agents I want it attached to the contract. He said, okay. So he says that the addendums to sell contracts, seller's authorization for hydrostatic test. It's going to have the property address. It's going to have the date. And in the first paragraph, it's going to cite from the contract, why are we having this written authorization? And it says pursuant to paragraph 7A of the sale contract executed by the parties on, that will be the executed date. Okay? So if you go back to page 8 and you see it blank, you're done. Because you can never, ever have a contract without an executed date. So be careful about that. Make sure that the executed date is always completed, because it has to go here, the executed date of the contract. Let me see if I can pull it up. Yeah, let's get some, if you can. I'm sorry, I don't know how that happened. I guess maybe because we've had 30 versions. Could be. But basically what this addendum is going to do is it's going to tell the seller that per the contract, that was a provision. And they're complying with the contract, all parties are. They're going to get the written authorization. And the interesting part of this is, my concern was, we have to make sure that the seller has done their due diligence. I don't want them to rely upon it, the listing agent to tell them what a hydrostatic test is. I say, because I'm telling all the listing agents, we don't ever recommend it. Because the moment we say we do recommend it, then they're going to blame us if something goes wrong. So it's in the different context. What I'm saying. Yeah, well, the seller can have a choice, even though I would not recommend it, because I need you to do your due diligence. I can't recommend something. You're going to have to satisfy on your own. The buyer has asked this, so we have several scenarios. If you don't let the buyer do it, the buyer's going to what? Walk away. If you do it and there's damage, or there's a result that shows that there are cracked pipes, the seller owns it. They don't get to pretend anymore. So you see, it's that scale, we're trying to weigh it so that the seller is aware that they must do their due diligence, but the seller also knows there could be a negative result on this test that they're going to have and own. They're never going to be able to hide from it. How many of you would ever recommend to your buyers to buy a property that has cracked pipes? We know that as a fact. And yet, we have a lot of transactions we get pulled in on because the seller has not disclosed a material fact. And that has caused major problems because they knew they would not do. Thank you, I appreciate it. Yes?
What is a hydrostatic test?
A hydrostatic test is a plumbing test for your sewer system. Okay? And what happens is they want to make sure that that plumbing line has no cracks in it, and that when they put that pressure, they're going to put intense pressure, and they're going to find out As they force that pressure through that pipe, will there be any leaks? If there are no leaks, there are no cracks in the pipe. So that's really the basis on that.
Is the pressure a lot more than the normal pressure?
Oh, sure.
I mean,
Oh, it's not like just flushing a toilet. It's like, yeah, it is a major pressurization.
so where they might not have been before, they're.
They could, well, no, they have first, every good plumber who does this test, and there's not, believe it or not, in Houston, you don't have a lot of plumbers who do this test, because it causes a liability on their part. So, first what we have found is that most of the time plumbers will use a camera. They'll go down, and if they can conclusively state 100% that with this camera, there's no problem, then everybody's great. It's a camera. Okay. But if the plumber comes back and says it's not 100% conclusive, we need to do the pressurized hydrostatic test so we can make sure that there are no cracks in the pipe. Because the plumber's going to be liable here if the plumber comes back and says there's no cracks and then it turns out it was wrong, that type of thing. Yes?
At what point would you instruct or, tell your client to get one done,
Well, as I said previously, you're going to have indications. If there was ever foundation work done on the property, or if the inspector says they recommend this, or if in your experience, there are agents who work in certain parts of town and they know that every one of those transactions that closed had problems. That's when you have to do a better job as far as knowing if you are familiar with the areas. A part of that is what's so difficult too, is when you work in an area that you're not familiar with. It's much like if I sold property in Midland, Texas, and I never lived in Midland or worked in Midland. You know what I'm saying? There's great risk when you go into an area and you're not familiar. And an agent who does a lot of transactions in that area may know a lot more about it. There's just, you run that risk. That's why you advise your clients to always make sure that based on what you're able to find in information and disclosures from the seller, that you advise them properly about what kind of tests to do and what you found to be the issue. Yes?
Years ago, I had a listing, and just like a buyer would hire an HVAC guy to go in and check the air conditioning, the buyer did hire a plumber to do the camera test because they had a huge tree in the backyard, and they thought the roots had grown into maybe the plumbing lines, and they wanted to check that for leaks. And so they ran the camera through there and found a cracked pipe, and the seller had that repaired. But I guess now with the hydrostatic, what if someone said, I do want a plumber to run the camera through, not necessarily meaning it would lead up to a hydrostatic?
Right. The seller may allow probably a camera, but they're never going to allow the hydrostatic test without written authorization. The camera is not invasive. It doesn't cause any displacement of anything. It's just observant. Okay. And again, the plumber is not going to probably say everything is great unless they feel 100%. That's what has been our experience. The moment they have a little doubt, they recommend the hydrostatic test as well. If they don't perform it, they may recommend a good plumber who does perform them. We are in the process of trying to get some really good plumbers in the area to join in a roundtable type of discussion regarding this, and try and facilitate what they feel are the areas of concern and what sellers should be aware of now. And it's not so much from a buyer's perspective, because all a buyer's looking for is what? Are there cracks? That's all the buyer wants to know. But a seller, because it's their home, they need to know and understand a little bit more. And a phone conversation maybe with a plumber is not going to work. We did a lot of investigation on the websites about watching it on YouTube and various other things. And so we're trying to find some really good plumbers who will not mind being interviewed, and we can share that so that you can maybe present that to your sellers as well. But nothing takes away from your seller doing their due diligence. And now that we have the form thing, it says, pursuant to paragraph 7A of the sale contract executed by the parties on the executed date, Buyer has requested that seller authorize buyer to have a hydrostatic pressure test conducted on the sanitary sewer system of property during the period of time that buyer is authorized to inspect the property under the contract. And the attorney called it the inspection period, which is during their option period. Seller, by way of amendment to the sale contract, remember how I said this is going to be attached to the amendment? Paragraph 9 is going to say paragraph 22 is amended to include and add the addendum to the sale contract, seller's authorization for hydrostatic test. And it says by way of amendment to the sale contract, seller authorizes buyer to engage a licensed plumber to conduct a hydrostatic pressure test on the sanitary sewer system of the property during the inspection period, provided the test must comply with all applicable codes and standards. Seller is aware that the test may reveal leaks in the sanitary sewer system of the property. Seller releases and holds harmless the buyer, listing broker and agent, buyer's broker and agent, and buyer's licensed track inspector from any liability or damages caused by or related to the testing authorized herein. The fee for this test will be paid at time of performance by either the buyer or the seller. Okay, that's negotiable. And if the seller does not authorize the test, they're going to just sign this addendum, sign it, and state that they did not authorize it. So everybody will have it in their records that while it was facilitated and requested, the seller said no. Again, as I said, for a buyer to go forward after a seller says no on something like that is very treacherous for them. But we wanted it in writing for your benefit so that nobody would say that I had a phone conversation and they told me no, they won't do the test. You see the difference with that? It needs to be in writing, even if the seller declines that. Yes?
So this is to attach after you have a contract.
Yes.
But if your buyers want to buy a home that has already had foundation repair, and they want to make sure that the seller is going to allow them to perform all of
You would attach it to the contract at time of offer.
Contract, okay.
Yeah, you can use it both ways. Most of what we're referencing is, most of the time the buyer doesn't know going in. And in 7D2, that would be notated and say, see attached addendum to contract for seller's authorization for hydrostatic test. Yeah, because it's going to be made part of the contract. If we found out during the course of the buyer's termination option period that in fact they were advised to get a hydrostatic test, then at that point in time we would attach the amendment. Also in that amendment, if you need to extend the option period, you're going to pay more option fee and extend the option period so that you've given that buyer and seller enough time to get all of this. As I said, the key thing here is that the seller is aware that the test may reveal leaks. That was the big thing. I said, we've got to have some way here on this authorization form that the seller is acknowledging that there could be a negative result of the test, okay? And so, it covers all of the points that I felt really good about it. Trek put it out there in our contract and said, just kind of like a free fall, so we had to come up with something. My concern was the ones that I have seen only release the buyer agent and their broker. And my concern would be you as the listing agent, you got this, and it doesn't release you, and then you get your seller to sign it, and something bad happened? Yeah, exactly. And so, because I think of all the bad things that happen in the transaction, I felt that this would be a cooperative form. If I were a buyer agent and I provided this to the listing agent for the seller to review, I don't think they would be offended by that. But they would be greatly offended and not most likely want to ever have their seller sign something that would not release them from any damages that could be caused. And again, it is a hard decision for the seller, but I want you to know that that's not going to be just a phone conversation that you have with your seller if the authorization is requested. It's going to probably be, why don't you come into the office, I'm going to show you a video and let's look at this, and then I've got a list of so many plumbers that you could cost to actually conduct hydrostatic tests. So call your friendly plumber who's been taking care of your property, or I've got a list, and that's what I'm working on. I'm trying to find the guys and gals in this area who are good, have a great reputation, to conduct this test, and it's not as easy as you think. I had to do this when, we had 5 lawsuits in one weekend on this, and every last one of them. Some of the homes were, estates, okay, where nobody had lived there and the executor or executrix was selling the property. Other ones were, one individual lived there and they didn't put a stress on the plumbing system. And so on that Monday, after that weekend I had where 5 people sued our agents, I decided I was gonna go out and I interviewed, found all the plumbers that I trusted, got their fee schedules. I mean, I got the whole thing so that I didn't have this issue again for the agents. I was really worried about it. Now it teaches us a lot more about how the parties who are selling the property, how they use the property. You know, if you had a family of 5 and everything was fine, you're probably gonna think, well, there's not gonna be a problem because they'd have more of an issue. Where we did have issues were where there had been previous foundation work done, and nobody could find out who the foundation company was, all this kind of mystery stuff, and yet the buyer went barreling through the transaction, I really want this property, and didn't do their due diligence, okay? The other ones were that there was an individual of advanced age in a property that did not use the dishwasher and the washing machine and the shower, putting a stress on the property. And also we found vacant properties were the biggest culprit. And those vacant properties, one of them was a flipper. And it was proven that we had the subs who were all subpoenaed, and the subs knew that there had been a problem before. That's bad for the flipper. Big time. He owed a lot of money on that one. Because we were able to prove that the subs that worked on the property, that it had already backed up once while they were out on the site, making the pretty granite countertops and painting it. You know, making it look beautiful, but structurally and foundation-wise it wasn't. So again, we know through our experience that there are things that we need to pay attention to and kind of point out to them. At any time, once you have brought it to their attention in writing, can they make a stupid decision? Absolutely, and I don't care. They can make all the stupid decisions they want as long as we have in writing that you advise them properly. That's the biggest thing. You're not advising them in writing was the big issue. And most of us talk or have a phone conversation or text, and we really want it to be a purposeful type of conversation the minute you know that there could be an issue with the property. Now, again, the biggest thing the attorney wants to make sure is that when the parties are asked for this authorization, that you as the buyer's agent make sure that you extend the option period to cover the test and the results that will be provided. Okay, just to make sure on that. That's the biggest thing. You don't want to ever not bring that to the attention of the parties. So again, if you receive an authorization form, say you're a listing agent and you receive an authorization form from another broker or an attorney, you're going to stop everything and you're going to send it to me. Okay, and the reason is if you're not going to advise your seller to sign something that we don't know or we don't know the use of the form. In other words, the promulgated forms, yeah, we know the use of it. We can't legally interpret them, but we know the use of them. If you receive something and it's based on this hydrostatic authorization, we want to make sure that you don't have your client sign something that might be to your detriment and your client's detriment. That's the way we know. That's why this form is kind of universal. A listing agent can provide it to the buyer agent if they've asked for it in the amendment. So it's one of those forms that can go either way. It's going to be used by buyer's agents as well as our agents. Again, if you receive it, don't let anybody sign anything until we make sure that we have reviewed it and made sure that it would be appropriate. Any questions on this?
Will it be added to the document?
It is already there. It's already there. Now that's what Nicole told us, that it's already there. I'm hoping it's the right one. But I'll find out and make sure that it is the right one. Okay. The next thing we're going to talk about is leases. How many of you have done leases? Okay. Have you represented tenants? That's the hard part.
Yes.
Representing a landlord, our lease listing agreement is very specific. It states that all we're doing is marketing the property to secure a prospective tenant. You're not performing a property management function or a landlord advice function or what should I do. But when we represent tenants, it goes so fast. They need to get a place, they need to get in. The whole process is very, very fast, and a lot of times we don't review everything that we really should with a prospective tenant, because leases are more binding on a party than defaulting on a mortgage. In fact, if you default in a lease, you may never get a mortgage. And because it tells the mortgage that you don't have a very good track record. If you broke a lease, why do I think you're going to pay? You know what I'm saying? And so that's what's been the result of it. That will send up more red flags and issues. And most of the time, what we have found when we've had these issues where tenants have broken leases in the past, there's no landlord that will ever lease to them again unless we've had like 1 month's worth or a year's worth of lease payments paid at that first month. Oh yes, we had a lot of those in the last few years. When we see those types of requirements where the landlord will say, I want 2 months of security deposit or 3 months of security deposits, or I want 6 months of lease payments up front, that comes from either there's an issue with the person's credit history or the credit report, or it could even be something as their history from previous landlords and previous issues. So a lot of times what we see in our MLS is for those that are going to meet the test and have everything perfect. A good credit report, good landlord history, good employment, all of those things. And just remember that the parties can negotiate, and how you facilitate that would be requesting from the listing agent up front. My tenant has these issues and we want to know, would your landlord even consider it? In other words, you're going to make sure that they don't put in a residential lease application and put money down when the landlord's not even going to consider it, because the terms are not the same as what it may be offered in MLS. So we do have times where we have to do a lot of finding out even before a lease application is done. My concern is that that lease application has to be told to the tenant that everything they include on that lease application must be true. Otherwise, the moment a landlord finds out that anything was not true, they're going to be automatically evicted. It's grounds for eviction. So you can kind of see how important that residential lease application is. And for us, we don't know if it's true or not, do we? But we will know if it's complete. Okay? So what you want to make sure is that the work numbers and all the phone numbers, everything is completed. Because that would be the first thing that the other party is going to say, well, they didn't complete it, we're not going to consider it if you don't complete it. I love the landlords that use the portals to say to the prospective tenant, go and log in and complete the application. I love that. That takes you out of the element of touching any of their confidential information. And on that lease application, if while it's in your possession or an attachment in an email, something happens, you're done. You will be spending money for the next 5 years so that they can be monitored through LifeLock and that. We don't hold confidential information of others. The Privacy Act in 2009 was very clear, and your broker abides by that. We have a portal, .loop, where the parties can come into it, but it has lots of things that are protected so that there cannot be somebody's manipulation or retrieval or taking of it. Once it's on our computers, it's free game. So that's why you have to be kind of careful about the choice of it. Some companies, management companies, will say you have to come to my office and complete it. You're out of that process. They're there making the application. Just make sure that there is a place where you are notated that you are procuring costs for this prospective tenant making the application, because that would be protecting your interest after you've shown them properties and that. What we have to require is that certain documents are handled properly. The information about brokered services, you know, the new one that's got everything filled in except for your information, and then all that the tenant has to do is initial it and date it. The buyer-tenant representation agreement, we have to do that for lots of reasons, but most importantly, in the event that you have a prospective tenant that you're working with, and they're interested in another property that's for lease out of this office. Intermediary permission cannot be implied. It has to be in writing, and it has to be done prior to you going forward with the property that's listed by the same broker. And when we send it back to you and said you don't have something, and you go and get something signed right then, you may be able to put that document in .live, but you're never going to be saved by those actions. I just want you to know, if you don't do it at the right time, you have violated the requirements by track for the notice of intermediary. So just remember that. It's a time element thing. I love it when an agent wants to get paid and they turn in all their documents and we say something is missing. We think you got it somewhere because we've seen all the stuff that you've been sending. And so we just think you're just going to go get something that was executed prior to your contract. And then all of a sudden I go down there and I look and I see the date is today. So I'm telling you, and I don't like to put it in writing because the broker would have to turn those documents over to Trek. And while we'll tell you if you're not complying or we received the listing with the same time we received the contract, that keeps your broker out of trouble, not you. Okay, and that's what I want you to know. This is an indelible record. We don't get to delete anything we write in .live. Have y'all ever noticed that? Yeah. You upload a document, you have to archive it. But baby, I can get to it. So they're never, you know what I'm saying? They never ever are deleted. Okay? That was the integrity of the system because they didn't want just anybody to get in there and delete something. And so what I'm telling you is that these documents must be initialed or signed and dated prior to you actually conducting the transaction for them. Okay? A copy of the fully executed lease and any addenda. We do want that. Now, it's interesting because the law changed in 2014 that the landlord was required to provide an executed copy of the lease to the tenant. They don't have to do it to the agents, but they are required by law to do it to the tenant. Otherwise, they're going to be in trouble. Okay, it's right there on the last page. So a lot of times when you aren't going to get a response from the listing agent or the property management company, who are you going to get that lease from? Your client, you got it. Your client has it. Y'all should be still on talking terms at this point. So that you should be able to get that, okay? You want verification. Mainly because if you don't have a copy of the executed lease, you know, you don't know what the parties ultimately agreed upon. We have this a lot with property management companies. They don't want you anywhere around as a tenant agent. And all of a sudden, they're adding all these addendum things to the lease, and you didn't even know, and you never got a chance to review it, much less explain it or talk to your client about it. And so just remember that goes on a lot with those management companies that use portals that say you have to go into my portal and do this. They kind of keep everything and they're not sharing it. And as I said, by law, the tenant has to receive a copy of the fully executed lease. The residential lease application. Here's my problem for you. I don't want you to have a copy brought in through a PDF file through your email. I don't mind if you have it in .live, because if you stay in .live, you're in a portal that is going to take care of all the privacy law issues, okay? Does everybody understand the difference? If you had a tenant who came here and they were in one of the conference rooms and filling it out, and you're going to have to go and scan it, you will have possession of it. That is not inside .live. The best way, if they're going to fill something out, is to set them up in the conference room inside your folder in .live and having them do it. That way, in .live, you can share with others, but nobody's going to have it on their web desktop. on their iPad, wherever it could be.
So if they send something to your email, you can't like put save to your computer and transfer it into, from documents on your computer, from
You
computer
would
and
be
document?
subject, see, the problem is you
Why is
have.
there that option then to even do that?
Well, there's an option because the system can allow, there's lots of times when we want to upload a PDF. But I'm telling you, in this type of transaction, it's gonna be dangerous for you because we don't have the loan app. Okay, that's done by the third party. But we are touching the residential lease act in the course of facilitating fund compliance. Okay, so that's why you have to be very careful.
Also, this is just for the lease.
What about pictures? Many times they ask you, oh, you can send me the application fee and a picture of the check to prove that the process is getting through.
Well, if you,
So you take a picture from your phone and you send it to the company management.
well, if you have a possession of the check, in your possession, you're responsible for it. So that's probably why they feel very trusting of just having a picture of it. Because if you have possession of it, you will have all the liability of delivery and that type of thing. Again, the biggest issue here is that you understand that if you have their confidential information, everybody knows that even if you deleted it, is it really deleted? No, it's never deleted. And see, that's where that Privacy Act, when it came in, was so devastating because we all knew, just because you wiped it off of your system doesn't mean it's gone. So be smarter about the way it's facilitated. If you represent a landlord, hopefully they're using My Smart Move through TAR or some other portal where they'll invite that prospective tenant in, and you're not going to have a copy in a PDF file that's going to be attached to your own system, your own hard drive. Okay, if you stay within .loop and have them completed, we're fine. Okay, there's a big difference because it's staying inside that portal area. The agreement between brokers. And everybody says, why do we need this, Marilyn? It's an MLS. Really? Well, let me just tell you why you need it. In the lease listing agreement, there is a provision that the landlord and the listing broker agree to provide compensation in the event that the tenant renews or if the tenant decides to purchase the property. You having this agreement between brokers means that you will receive compensation. If this tenant bought that property, you can go to the listing broker and get your compensation. Okay, that's the reason we do it. Sometimes properties are not placed in MLS. MLS is a unilateral offer. If you found it in MLS and they don't do what you printed out at the time that you submitted the offer and the lease was executed, we have other means that we can go after them. They're costly and usually more than what the lease commission is, but there is a way that we can go after them and say, you either do this or we're gonna pursue you. But the problem for the tenant agent is they don't know what that tenant's gonna agree to. And we would like to know, for your benefit, if you could be entitled to renewal compensation or compensation in the event that that tenant purchases the property. So that's why you need to get the agreement between brokers. Do y'all think that that would be in your best interest? Yes. You bet. You bet. I know of a horrible story. A lease listing agent received an agreement between brokers from the tenant agent, right? Didn't look at it. Just signed it and dated it and sent it back to the tenant agent. And unfortunately, a year later, he owed a humongous amount of money to the tenant agent and broker. And what happened is in his lease listing agreement, there was no compensation for renewal. Or in the event this tenant bought the property, none. Those paragraphs on that agreement between broker actually come from the listing agreement. And what happened is he didn't look at it, go back to his listing agreement based on what his landlord was going to pay him. Instead, he just signed it and sent it back to the other party. Now, you as an agent, you can't put terms in there that are different than what's in MLS. If they put in there an MLS about other compensation, about renewal and sale. In other words, you should know from that MLS listing if they are going to provide it. Okay. If you leave it blank as a listing agent, I think it's up for grabs. The buyer is gonna, the tenant agent's gonna assume the best and send it over, and you're the one who has to say if this works or it doesn't work. The interesting part on this scenario is the listing agent says, I went back to my landlord to see if I could get him to pay it. And he said he looked at his lease agreement and he was very emphatic that he never agreed to it. And that was the saddest thing. It was a very costly experience. It was over $7,000. It was for a big high-rise over near River Oaks. That's why the tenant agent got the agreement between brokers, because they knew that was probably a good possibility that they were going to renew the lease. They knew kind of what their tenant was thinking in that. So again, it's important to pay attention to that point. Yes?
So I have the right as a leasing agent to put 0 or not applicable to the renewal fee if that's my decision or my deal with the landlord?
It better be based on what the lease listing agreement had, that the landlord agreed, because the landlord's the one paying the commission to the listing broker. So if you had 0 for renewal and you had 0 for sales, you better make sure that agreement between brokers is 0.
I got you.
And you would have to send it back to them and saying, we're not gonna sign this form. I need you to initial that I crossed through the compensation for renewal and for sale. In other words, you wouldn't sign it and send it back, you would cross it through and have them initial it. Okay, you would initial that cross through as well. So again, you have to be very careful about that. And as I said, it is a devastating thing for a listing agent not to know what was in their listing agreement and sign it. So, you know, he never made that mistake again. He, as I said, it was costly. He tried so many ways to figure out how to not pay it, and I said, you're done. You have to pay it. And so, again, it was a very deadly mistake because it's not like our typical lease payments that we receive at the time that we have a tenant going to a property. The next one is the landlord's tenant selection criteria. On the residential lease application, right above where the tenant signs, it says that they've received it. If there's anything that is not true on that application, those tenants are subject to immediate eviction and problems, okay? So as a tenant agent, if I've asked for the landlord's rental criteria, selection criteria from the listing agent, and they said, what? You know that they don't have it, or they're saying we don't have that, you're never going to have that tenant sign that application without marking through that they have not received and have them initial that. Just be careful about that, because you don't want them to say they've received something when they never gotten it, that you never got it. Because they could say, oh, you got it, you just never gave it to them. See, and I don't want that to happen, because that's what they'll turn on. Yes?
Do we have a standardized form?
There is no standardized form because that's the landlord's criteria, not the listing broker. The landlord is required by law to provide that. That's why it's in the residential lease application. In other words, because the federal law says if the tenant has any adversity on their credit report or their credit score, the federal law says you have to give that formal adverse notice with all the fill in the blanks. Our problem is we've had listing agents who've gotten in trouble because they didn't advise the landlord to provide the landlord rental criteria, and then the landlord decided, well, I'm turned them down because of this, and the tenant never had an opportunity to say, well, then I would never match that criteria. Why did I ever put in my application? And you as the listing agent will advise that all fees have to be returned to any applicant who is turned down that was never given the landlord rental criteria. You don't have to give it back if they're turned down because of the credit history or credit score, but you would on anything else. And if you look at paragraph 20 of the lease listing agreement, it gives what the landlord's asking. They're saying, I don't want any pets. I don't want any smokers. You can only park 2 vehicles. I want a credit score of, 730 or better. You know what I'm saying? There's all of those things. And so when we take a lease listing, we want to receive that from the landlord, because the landlord then will have a very good way to say to the prospective tenant, you didn't meet my criteria, I gave you that ahead of time, and you've been declined because of that. What causes problems for the agent, listing agent, when they have a landlord who says, I've declined this application, if they can't tell you why, you got a problem. Okay? It's real easy when it's a credit score or credit history or criminal background check, all those things that are going to be taken care of. But what would be very problematic is that they've said, well, I just don't want to. No tenant is going to be happy, respective tenant is going to be happy with just being told because the landlord didn't want to. That causes us, it's a danger zone for us. So again, just make sure if you're the tenant agent, that if you didn't get that, you better ask for it in writing. If you did not get that, then the tenant has to know, look, you're going to go forward, and we have no idea what the criteria is. Okay? Again, as a listing agent, that landlord rental criteria is a perfect way for you to look at it and see if the landlord is using any discriminatory practices. If they are, you're going to stop it right there. Okay, you're going to know exactly that you can't go forward with this. And that's where we get into this area that gets kind of crazy and is deadly for us, because we've got landlords who say, I just didn't want to, and they're never telling you why, and that's not a very good position for you to go back to a prospective tenant agent and their tenant telling them that he just or she just decided not to. The last thing is that the landlord declination. That was what I said. Federal law requires that if the landlord declines because of credit score or credit history, they have to complete that form. So if you are a tenant agent and the landlord has said, I turned you down because of your adverse report or credit score, they have to provide that form, and we have that form in our property management forms. And it's the adverse notice that the landlord must give to the tenant in writing. They are required to provide the reporting agencies, their phone numbers, everything about it. But they can never, ever give a copy of the reports to the tenant. Never, ever. If the tenant asks, well, can you share that with me? No. All we share is the detail that the landlord is required by federal law to complete and send over to the tenant. So if you're a tenant agent, make sure that that process is done if your prospective tenant is turned down because of the credit score or the credit report. Okay? You better get the adverse notice.
And if they tell the credit bureau that they were turned down, it's sitting free.
That's it, and it is right, but the landlord can't give that report,
Right,
you know? And a lot of agents think that the landlord can, and they'll ask for it. And just make sure you understand that the tenant knows that because of the landlord completing this notice, we now know on Experian it's this, and you can go to them and find out, and they'll give you a copy of the report. So we don't get involved in the technicalities too much of it, but we do want to make sure none of the landlords give that report out, and that as tenant agents, you don't ask for it. Okay? You tell your tenants what you know. The last thing is the MLS printout. Why do you think I want you to have the MLS printout at the time that the lease is done? Time you send over the lease. There you go. In MLS, that is a unilateral offer. What that means is the other broker has to give you that, and it can have no conditions. It can't be an acceptable offer or 12 months. It can have no conditions on it. It is given. And what I want is proof, and because at the bottom on your MLS printout, it has the date and time, what it was at that time. We've had several of them just recently that changed it after we kept trying to collect it because we had a copy of the MLS sheet, and they went back in, and we had to go to HAR and get Nathan Goebel on it and a few others, and finally the listing broker said, we'll pay. So again, and I am going to tell you, this is horrible, but we had a situation years ago. You know how you denote the compensation and 50% how it looks? Okay. In the HAR, in the MLS here, it said 0.05. Oh, right? Whoa. It cost us more money to calculate compensation. And and the listing broker, who used to be with Keller, he was asked to leave. He played the cards, that's it, that's all I'm gonna give you. Now, we have had a lot of listing brokers who've made mistakes. And when we brought it to their attention, did they do the right thing? You bet, they did do the right thing, because they knew that it was wrong. But that one, I'll never forget, 0.5, and oh my gosh, I'm on the phone trying to calculate it, and I'm thinking, oh my God, that's like 3 cents or something. It's just ridiculous what it was. I mean, you could tell that was not being cooperative. I would not consider that cooperative at all. So again, that's the reason we do that. It's because we want you to be protected in the process. As I said, the transactions for leases go very fast, don't they? We've spent more time talking about it than you probably ever spend time talking or going through the lease with your tenant. And leases are complicated, extremely complicated, and they all are law. It's not just what a landlord decided to make up. It is because it's taken from our law and placed in a form so that all parties are understanding what the provisions are by law. So again, just be very careful about the actual documents that you're going to need to complete it. This declining, this is TAR 2212. So if you're a tenant agent and the landlord has said we've declined, and you said, well, is it because based on the landlord's rental criteria, or is it because the credit score or credit report? If it is credit score or credit report, you are going to ask the listing broker to provide the federally required TAR 2212. Okay, so just remember there's that element of that extra form that's needed. We have successfully gotten after listing brokers who we asked for the landlord criteria. They said there wasn't any. And when the landlord says, well, they turned them down because of this, and the tenant agent said, well, had we known that, when I contacted you before, we never would have put in the application and spent the money. And we've successfully gotten reimbursement. Okay, because that's not the way this works. And landlords, I'll be real honest, they should know better, but they have a representative. And that's who is facilitating this in their behalf. So many times, you know, I just want you to be aware that if you are the lease listing agent, you make sure that you pay attention to that as well. Just some points. Do you have to read this lease with your tenant? Absolutely. And that takes a long time. It does. And what's so funny is as you go through it and you're reading it and all these statutes are quoted and the property code and all these other things, and you're going, they're already asleep at the wheel. They're just not paying any attention to this or anything. The biggest thing I think you have to understand what your position is it is to present the lease that your tenant wants, okay? So it's a negotiable document. They could be approved for the application. Does that mean they're going to get the lease? No, there's the difference. So you kind of, you know, you have to let them know that this lease is the binding document between the parties. If your tenant doesn't want the landlord to gain access without permission into the property, you're going to have to write that in, because in the lease, anybody can get in there and they don't even have to call ahead of time. And not very many tenants would like that. Access to the property, you got to pay attention to certain provisions in the lease. Because if a tenant says, well, that was never brought to my attention, they really can't say that they didn't read the lease, because that would be bad for them. The other thing I'm going to tell you is that you're not a property manager. The moment they start asking questions that are more property management or that they're clarification, you're going to say, I don't know the answer to this, but I'll get it for you. You're going to put it back on the listing agent. You're going to ask the question and you're going to give the response to your prospective tenant based upon what the listing agent or landlord has facilitated as a response. Don't take it upon yourself to just answer it. Oh, in my experience, this is what I've done. Make sure that if you understand the process. This lease is negotiable between the landlord and tenant, but the tenant needs to maybe know some things ahead of time. The biggest thing that we have problems with is that all the utilities are not available to the property. And when a tenant signs that lease, they said they've done their due diligence, they've inspected it, they've contacted all of the companies that provide service, they've checked the internet provider, all of that. How many tenants do that?
Not very many.
Yeah, none is right, exactly. So, just make sure that, you know, you ask the listing agent for the landlord rental criteria. Any fees that you receive, you as the agent should complete them, as I said, through EDGE or zip forms. In other words, in a portal where the parties go in rather than you having an attached PDF file. Don't maintain a copy of the application. Don't have it in your possession, okay? If it's in paper form and they provided it to you, you scan it directly from the scanner here to the listing agent, you're gonna turn and say, this is how I handle your confidential information. I have shredded it, okay? So just remember, if you have paper in your possession, you are able to tell them what you did with that paper file copy. You shredded it. Y'all have shredders here. You know, you put it in a box and somebody takes it away and shreds it and stuff like that. So just remember, if you deviate and have the information and it's not inside a web portal, you're gonna tell them, this is how I'm handling the information you just provided. I have deleted it, I no longer have a copy. Okay, make sure you keep your copy in the event something happens to the copy we sent the landlord, that kind of thing.
I have a question.
What
if we do not continue to use a company that has .loop if we've deleted all these documents?
There's no .loop, never deletes anything.
I'm saying, but if I move to a different company and they don't use .loop, do I still have access to it?
You would only gain access through the broker here. The broker maintains all of those files. So we have copies of every transaction that is involved with this brokerage. But once you leave here, those files are the property of the broker. So if you needed information or there was a dispute about it, the broker would have to be the one to provide permission. Okay. If you upload a confidential document to .loop, like checks, most of the checks and leases are cashier's checks. So we're really pretty good because we don't have account numbers. But I just want you to know that that works for, you know, when you take the copies of the option fee check and the earnest money check, I just want you to know you have to black out the account numbers on those checks before you send over a copy to the listing agent, letting them know that you have copies of it. Okay, so just be careful about that. You know the emails that we get that said somebody left some checks on the copier? That's the problem. You see the risk that you have? Big time. Because you made a copy, but you left the originals on the copier. Okay, that's why it's so critical to make sure that you at all times dispose and take care of any confidential information that you have with your clients. The other is, again, as I said, don't assume anything about the lease. If you need clarification about what the landlord's interpreting it or what the landlord's instructions are, you're going to try and get that response through the listing agent. And the last thing is, there is a lead-based paint disclosure for leases. It is different than the one for property for sale. So be very careful. It's 2008. That is attached to the lease, so those all have to be completed and the notice done. And the reason it's so important is because that's a federal law. Okay, that's not a Texas law or a Keller Williams one. That's a federal law about advising the proper notices to a prospective tenant regarding lead-based paint. Now, I am going to tell you that before we get to the changes in the lease, I'm just going to let you know what happens. You placed a tenant in the property, and in 3 months you get a call. I don't like this property. This landlord is not good. They're not doing all the repairs, and you're going, who are you? you have an issue and a situation that is very delicate, and here's how you're gonna explain to them. You're gonna listen to them and all that. You're gonna say, do you have a copy of your lease? Because you know, I have a copy in our files. I can retrieve it, they're archived, but I can get one for you. Do you have a copy of your lease? And they're gonna say yes or no, and you can send it on. The problem for you is that you cannot interfere in this lease by advising the tenant what to do, complaining about the landlord, making any disparaging remarks about the landlord, or assisting them in how they could breach this lease. That is a document, an agreement that legally binds the landlord and the tenant. If you as an agent stepped in and said, and called the listing agent and said, you know that landlord you had several months ago? My tenant is upset because the landlord hasn't, it's none of your business. And you don't get to get in the middle of any of it. They're gonna think that it's your job, but you're gonna have to be very careful. I'm prohibited by law from interfering in this lease agreement with your landlord. I advise you to get with your landlord, place everything in writing, make sure per the lease it says in writing, and they probably need to always send it certified mail return receipt requested if they've gotten into multiple notifications. Those are good things you can just say in general because they're advised that way in the lease. They don't ever get to have a conversation with the landlord. Everything is binding if it's done in writing. But for you to assist that tenant in any way, shape, or form that could be considered interference in that lease, that landlord could come after you. And you're gonna have to let the tenant know, say, you know, I'm so sorry, you know, I cannot get involved in this. The law prohibits me from interfering in your lease with your landlord. Do you have a copy of the lease? As I said, you might need to seek legal help in the event that you've got a legal question. But don't get in the middle of it. I have one now who, he said every 3 months the tenant would call and complain to him and now is blaming him for the property management company. And that's because all along this lease, he's listened to, you know what I'm saying? He's kind of invited that tenant to think he was still a part of that lease. And many times we become friends with people after we work with them. That's different. But in this instance, you cannot give advice. Unfortunately, we had an agent who was sued $60,000 by the landlord for interfering in the lease. And that's the problem, is because the agent shot off an email to the listing broker, and the listing broker did what? They forwarded it to the landlord, and there it was in the writing with Keller and everything, all that they were saying about that. Yeah, don't do that.
Okay, question. I had a client who, when we showed the property, it had a pet smell. In writing, he accepted the property as is, but when he paid the lease, the first month's rent, 2 days later, he spent the night, and he's like, I can't stay here, it stinks. So he contacts me, and I basically tell him, you've signed the lease, there's nothing I can do. And he got upset. Was I correct?
Yeah, you can't interfere with that signed lease agreement.
Okay.
He's already taken occupation.
Yeah, so he gave me a horrible review, and I was a horrible agent, but there was nothing I could do. He signed the lease.
Right, and if you are showing a property and those issues come up where there's odors or smells or they have allergies or they've got kids with immune condition, you're gonna say what? You're not going forward unless you put in this lease what you are requiring this landlord to do.
But he told him, the agent said, we're not changing the carpet, we've already shampooed it, will you accept it, yes or no? And he signed yes.
But he had the opportunity to negotiate. He chose not to. He asked, they said no, and he went back and accepted it. As long as you had all of that in writing, his remarks were horribly unfounded. But that's how they feel. They try to pull you into this, even though it's not part of your responsibility of that. That's why I said, if they have any hesitation, they've got to make sure about all the utilities to the property, all the internet connection, all these things, because when they sign the lease, that's what they've said they've done. So you don't want them to sign something unless they've done that. If you had an email that said, you know, before you sign this lease, you need to do blah, 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 and they said, everything looks good, we're fine. You've done that. More than just telling them, it's in the lease, you've also advised them about that. Now here are the changes in the lease. It involves paragraph 10D-S, that's the first one. And what they added was the cost to repeat certain security devices is provided in paragraph 19, which talks about security devices. What's interesting about this, there were all these lawsuits regarding when a landlord interpreted the lease in its very broadest sense, that, hey, these are reimbursable expenses because I have to go and do this because you abandoned the property or you didn't return some items, those type of things. And so there became this big issue. And what they decided, the association, because they were aware of all of those lawsuits, that they decided that they would change the lease, get the law to change, so that now in the lease agreement, the statute is there where the tenant now knows that they could be subject to the charges that a landlord may do because of these things. The next part that is modified is paragraph 19, and that's where the security devices and exterior door come in. And in that paragraph, it says, all notices or requests by tenant for rekeying, changing, installing, repairing, or replacing security devices must be in writing. Installation of additional security devices or additional rekeying or replacement of security devices desired by tenant may be paid by tenant in accordance with section 92.162C of the property code and may be installed only by contractors authorized by landlord. This gives specific language about rekeying and what authority a landlord is requiring that the tenant get in writing. And the last one is paragraph 27, default. And this was the one where a landlord looks and says, what can I charge the tenant for? If the tenant's in default, what are these charges that I can charge them? And it says, it's interesting because A always says the simplest thing. If landlord fails to comply with this lease, tenant may seek any relief provided by law. But in paragraph B, it is more explicit. And that's what they had to add. They had to add in paragraph D, if tenant vacates the property in breach of this lease, landlord may also deduct from the security deposit the reasonable cost to rekey certain security devices as provided in paragraph 19 that we previously worked with. This document, as I said, is probably one of the most straight from the statutes documents possible. Our association, this is not a promulgated form, this is provided by our association. And what it does is it complies with the Texas Property Code. So that the landlord, if the landlord didn't know anything about being a landlord, they could read this and know. Then they go to chapter 92, which actually is in all the lines of the code. I think there's like 5,000 lines for what a landlord is required, as well as a tenant can look at that as well. What I am going to say is that this one change does not affect the leases that were done previously. Okay, remember how I said the law changed on January 1, so that's why the document changed. And if they had an executed lease on the old farm on 12/31, then that's going to hold. What happened was, instead of it being interpreted broadly as it used to be, they really specified it here. So now a tenant will know that these are normal and customary charges that a landlord can deduct from the security deposit. And the security deposit is really governed strictly by what a landlord can do. I always get these calls and they say the landlord wants to know if they can deduct for this, this, and this. Now, this is an agent who wants to lease the property. They're a lease listing agent, right? And they call me and they said, oh, the landlord wants to know if they can deduct this. The tenants have already vacated the property, the new agent is listing it for lease, and I tell them, I said, unfortunately, you can't tell them anything. You are not a property manager. You're not going to give any advice. And so a lot of times what happens is when they hire you to be the lease listing agent, they think you're really going to advise them based on what the landlord should and should not do. In other words, what property managers do. And that's the problem, is it's that expectation level. And they're gonna say, well, the other agent I had did that, and you're gonna say, well, I can't account for why they did that because it's not in my lease listing agreement with you. At no time does that agreement appoint you as a property manager. Okay? It's very specific for your duties, and so you never wanna ever cross over on those boundaries. The other thing I'm gonna tell you just really quickly, even though we talked about the leases changes here, if I were a lease listing agent and there is a tenant still on the property, you don't have any communication directly with the tenant, okay? Anything that needs to be done, like a key box authorization form, you're gonna provide it to the landlord and you're gonna tell the landlord to get the tenant to take care of it. You as the lease listing agent, having any interaction with that tenant is deadly for you. We've had lots of truck complaints, lots of them. Fortunately, the lease listing agent was trying to help and be helpful with the landlord because the landlord lived out of the country. Well, I don't know how a landlord could live out of the country and take care of that property with a tenant in it. Do you? I don't know. Anyway. What happened is, fortunately, this lease listing agent brought another agent with him. And the tenant became belligerent, abusive, throwing things, those kind of things. And then they filed a complaint and sued the listing agent because they came on the property, they interfered with the lease agreement with the landlord. And you see, that's why, you know, your lines of what you do within these types of transactions is, it's not that you're a bad person or that you're not helpful, it's that you can't. And in particular with leases, we have to be very careful because on that lease, the only mention of any broker is, will that broker act as what? A property manager. That's the only thing you see. Otherwise, you're not anywhere on it. Okay? And there's a reason for that. You're not a part of that lease. Okay? That is between the landlord and tenant. I am going to tell you that the biggest thing that you have to be concerned with is the time element involved when you work with tenants. It goes very, very fast. They usually don't have the luxury like people who are looking for a home to purchase, you know, where they spend more time with you. This is mostly get it out, find a property they like, hurry up and do this application, and the part of the lease is it's sent over sometimes by the listing agent because they know what the seller has placed in paragraph 20 of the listing agreement. They fill in what the landlord requires, sends it over, and then the tenant will fill out the rest of it based upon what they want. At that point in time, when you facilitate that without explaining it, that's going to be your biggest problem. Okay? No client can ever be asked to sign, initial, anything without having you review that document with them. And so to protect yourself when you do this review, because I know you go over it because they fill in the blank or they've answered your questions. If you send it through Dotloop, make sure you CC yourself in that discussion on the message. And you're going to say that, I know we reviewed this over the phone, but again, if you have any questions, please contact me before you sign this. Okay? So protect yourself, showing that you have reviewed it with them, and to make sure that if they have any questions, that they contact you before they sign it. Okay? That will take care of the element of you being told that you never went through it with them. That's one of the other things that we get challenges with tenants when they come back on the broker and say that the agent never explained the lease to us or never told us this or that type of thing. So when you send out the notice and you've gone through it with them on the phone and they haven't been face-to-face with you, make sure that you put that in that message back to them, okay? So that you're covered on that type of thing. Okay, anybody have any problems with our new contract forms? Yeah. Everybody has no problems with the new contracts? When does the last day of the option, when does it end? 5 p.m. Yeah. Where the property is located. Right. not where the buyer's located or where the seller's located. Especially if you're in a different time zone that's different than what we have in coast to coast on something like that. The next thing I am gonna tell you is, I mentioned it last time, that no option period can be extended without monies being paid. Okay? We're gonna be, yes, really. In paragraph 20, pardon me?
Even if both of them agree?
It has nothing to do with that. An option is defined legally, and in paragraph 23, it says that if you don't give money, you don't get one.
What about lease back?
Pardon me?
What about lease back for private residential lease? Would it be zero?
The leases are different. That's a landlord tenant.
No, the lease back that to the contract.
Yeah, the temporary lease. Yeah, that's why I said that's between landlord and tenant.
But could be zero?
They can decide that. It's stupid, but
Well,
they
but
could.
I mean, it still have
Yeah.
legally effect.
Yeah, they can decide that. That's in that form. Option is defined legally. And there is no option that exists unless money is paid.
Marilyn.
It can't be $1 or $0.
Oh. What if it's the owner that wants to extend it so they can do, you
The
know?
buyer is gonna pay for the privilege to tell that owner, I have an unrestricted right to terminate. And in order to have an unrestricted right to terminate, that buyer has to pay.
I have a question about leasing, you may have touched on it, but, okay, so credit report is, and number is required by the seller. The tenant has to send that directly to the owner or to the agent,
What?
their credit report.
The tenant should never provide that report. The landlord needs to go into, the tenant is paying a fee so that the landlord will go in and run the credit report and credit history, okay?
But they said they are not gonna charge them if they provide their own.
So a landlord has asked for that?
Yeah.
Okay, just make sure you have all of that in writing, because,
So
you
do
don't,
they provide it to the listing agent or to the owner?
well, you can provide it to the listing agent, they would have to give it to the owner. But again, that's very rare that we have it, because no listing agent here would ever advise a landlord to accept a report from the tenant. They're gonna have to do it independently. Yeah, but you know what I'm saying, we don't do that, mainly because we also, you know, it's just, that landlord needs to do it, because what if you told the landlord it's okay, and it turned out not to be okay? That's the problem. Yeah, that $60,000 that we received, I found out when I went through and started investigating, because I looked to the residential lease application, because to me, that is the one that's so deadly on the tenants, because if they lied, it's an automatic error. Now, you as an agent cannot verify the information. If you verify for the landlord, you're done. Okay, you'll be in trouble, and that's what happened in this instance. The landlord had the listing agent and their assistant verify the previous rental history, contact previous landlords, the employer. You can't do that. Okay, that was the problem, is they were acting as a property manager rather than the landlord doing that. The landlord successfully won in court against this tenant, and then they turned around and said they lost so much money and all this, and they wanted to sue Keller Williams. What was interesting is when I went back to the residential lease application, I thought, well, the landlord and, well, the listing agent said, we called these numbers, and this was the response. They had a beautiful log that showed me what they had a conversation with everybody that they talked to. So I started investigating, and I started contacting these numbers on my own just to find out. And what I found out was that a friend posed as this employer, and they're up here in Spring. And if you look, and I Googled them and did a little bit more investigation, and these two parties knew each other quite well, and they had been doing this kind of thing for each other, but they pulled an employer because they used that employer's comp. So I got them fired. And the lawsuit dropped because the landlord had no provision to hold us to people who lied. that kind of thing. You know what I'm saying? They were misguided in trying to hold the agent responsible for people lying. So it's very important on those lease applications, you know, that information is critical and vital. And that's why tenants have to know, don't you ever put anything on here that's not truthful, and you better complete everything, because it could nail them. And again, when somebody threatens us and sues us, and it's for that much money, and the agents were really doing the service for the landlord, and then that landlord turned around and sued them.
Why would the agent even want to do that?
Well, here's what happens is, our attorneys talk about it many times. When we have a scope of duty, okay, TREC has said this is your duty, and a lot of it's very broad. You have to be a fiduciary, accountability, and these type of things. So they don't come down and say you have to do 1, 2, and 3. What happens is when agents go out there and sell themselves and their service, sometimes they just do things that are not within the scope of what they agree to in writing, like the lease, listing agreement, as well as the listing agreement or buyer-tenant agreement. They've extended themselves above and beyond the written scope of what the parties have agreed to. And that's what happened. And the listing agent had been doing it for many years. They stopped it. After this lawsuit, they stopped it because they just were trying to offer a benefit. And they knew this landlord. They had done a whole lot of business with them over the years too. And it was kind of sad because the landlord had won in court and gotten a lot of money in court from the tenant, but still felt that the attorney who represented them felt that that was what happened. And we were scared because we were doing something, the agent was doing something that they thought was helping. And they got nailed. As our attorneys say, no good deed goes unpunished. Yes, sir.
A question. Okay, so if you're the listing agent on a lease, someone submits an application, you know, they have another realtor and everything. We're just presenting that information to our client, correct?
Yes, sir.
That's it. I'm not verifying anything.
No. The moment that these agents did that, and they verified, oh, they've had rental history with these 3, we called these 3, and this is what they said. The moment they did that, that's when they opened themselves up. And landlords, it's real interesting. I have a lot of agents who call and ask questions, and they're landlords, and they want help. Well, if you're an agent and you don't know what the code requires of you as a landlord, that's pretty serious. You don't want to be a landlord until you are proficient in understanding, because that code is very deadly against you. And that's what, and a landlord, they have to be serious. That's a serious job. How many of you have ever been landlords? It's tough. Under the best of circumstances, it's tough. If you've got a great tenant, there's no problem. So you're thinking there's never an issue. But if you don't have a tenant that performs perfectly, there's a lot of issues in what you're governed by, and the law changes now every 2 years about how you have to post it. We had an agent who was sued because she posted something, but she didn't open the door and post it on the inside of the door. And that's the law. Yes.
So piggybacking on what Tony said, so if you're the listing agent for the lease, the landlord has to call and verify all that.
Absolutely, you don't get to do that.
And if we put it on Smart Moves, just have everything sent to the landlord.
Yeah, and the landlord goes in and gets the criminal report and all of that.
But we shouldn't pull it or look at it.
Oh, okay, because see, I have a lease listing right now. Okay, I went to Smart Moves and set up a profile for me as an agent. Okay, and what happens, like I have an app pending right now. Okay, so you send you get the email for the client, for example, and email it to them, but it gives me access to view it. So how do I get it from there to the landlord?
You're going to invite that landlord in. They're going to go in and get that report themselves.
Okay.
Yeah. See, that's the portal through TAR is if there are property managers that can utilize it, or if the landlord. But we usually invite the landlord to go in and use that so that the prospective tenant goes into it, completes it, and the landlord has all of the documentation, all the reports.
One last question. So if we're doing a lease and they do that TAR 2003 online, you're saying we're not supposed to look at it to check their income and make sure they do 3 times the income and all that, just send that to the other agent?
Yeah. Yeah, because the landlord rental criteria that you would have received as a tenant agent would have told you what needs to be done. And if they didn't provide it, you can't make a comment because you have no idea what a landlord's gonna do. Okay. We have guidelines that we go by. Landlords even have those same guidelines. This is how they determine if this is going to be a viable tenant. And they do it several ways, financially, and then they do the criminal background check as well. So, yeah, you as the tenant agent will never sit in judgment on the application. The only thing that you're going to be involved in, as I said, is if you've got a tenant that has a history that's going to be negative and perceived negatively by a landlord, then at that point in time, you usually have to find out, will the landlord even consider the application from these tenants? So
basically, you're just presenting all offers.
right. Yeah, you present the information. Again, as I said, tenants, when they work with you, sometimes they don't tell you all the bad stuff. You know, and it's really sad because they spent this money on putting in an application, and there was no way that the landlord would ever agree to that. And we kind of know that landlords, you know, typically want a tenant who can prove a track record that they have successfully been a tenant before and they've left the property in a good condition. It's interesting. We had one landlord who required to meet the tenants personally before they agreed to a lease. Do you think that could be done?
I mean, basically, I already asked for everything, asked for a driver's license, a security number, so why do you need to meet them?
Well,
I know why.
well, that's a treacherous area because you can find out that the landlord, most of the time, the landlord is looking at it from a different perspective than we would, and we don't want them to discriminate because they want that. But can a landlord request to see the current property these tenants are leasing and the condition of the property? Absolutely. Notice I said condition of property. That's different because that landlord wants to know, how do they keep the property they currently are leasing? And it was interesting because it is property condition. It's not about the individual. It's about the property condition. And a landlord could have that right to do that. Yeah. They don't want somebody in their property if they've not been taking care of the other property. So again, you have to be very careful because if that is what the landlord wants to do, the landlord, without you around, could say, all lease applications must be completed in my office. Can they do that?
Yeah.
Absolutely, you certainly can. And just be aware that if you feel at any time there is discrimination against your tenant, you bring that to our attention. Okay, so you have to pay attention to that. There are certain things, like I said, property managers, they do the same thing, don't they? Come to this office and fill out the application. Most of them want to see them in person and those things. If the landlord wants to find out what the property condition was when the current, sometimes current landlords are very hesitant to give information about the tenant because they're afraid that the tenant will have reprisal against them. So again, as long as it's about the property condition. A couple of months ago, we talked about the protected classes, and we talked about those that are handicapped, and that one of the handicaps provisions was alcoholism, right? Mm-hmm. Drug addicts. Okay, that is considered a protected class. In other words, they can't be denied just because they're an alcoholic. But a landlord could state, based on things that have happened because of their alcoholism, in other words, were they disruptive with other neighbors and the previous life? Do you know what I'm saying? They're not associating their criteria because they're an alcoholic. Mm-hmm. They're basing their decision because based upon the alcoholism, this is what they did when they were occupying this previous property. So there are some things that are kind of touchy when you get into those type of things. But a landlord on the face couldn't say, well, I'm not going to rent to an alcoholic. They may have in their landlord rental criteria that no alcohol is to be consumed on the premise. Can they have that right? Yes. Yeah, they can do that.
And the whole property?
Yeah, on the landlord rental criteria, same way, can they say no smoking? Absolutely. So in other words, the landlord can have their criteria. The landlord couldn't say to them, they're an alcoholic, I'm not gonna lease to them. That is discriminatory practice. But they certainly could say because of their prior behavior or their history, disruption and all these other things, it's different. So again, leases, everybody thinks they're so simple. They're not. And, yeah.
Every time I get a client, they pay for a house and they want to lease it out, and they want to become a landlord. I tell them, I said, you better make sure that they're on laws. Everybody wants to do that.
They want to be a landlord. No, they don't. And it's really hard because we like investors, people who want to invest in property and have portfolios, but they have to make a commitment to either hire a professional or they're going to learn the law and they're going to know what they can and cannot do on something like that.
Okay, so I stepped out, I just want to make sure, if we're the listing agent for a lease, we cannot verify employment on the rental district, or land.
Yeah. And if you looked at the KW special addendum that was created that you have to use, that's what it says.
Why do we have forms? Why do we have forms?
Why do you have forms?
The forms to verify employment and verify rental history.
No, you don't have that. That's just a part of the residential lease application. But you have a special KW addendum that has to accompany every lease here, and it clearly states that you will not do that. That's what the broker created, so that you wouldn't be caught trying to tell the landlord, I can't do that. They put that addendum in there. So, because it's not in the listing agreement for lease, it's clear that we don't do property management and we don't vet the tenant and that type of thing. But y'all have a special addendum that you have to have attached to it.
Well, but what about that form that there used to be that said verification of rental and employment?
Right.
Is that not around anymore? Okay.
As I said, because of the rash of lawsuits that happened a few years ago, there's great liability because the insurance company that provides your errors and omission, if we submitted to them a lease listing agreement, they found out that you did a property management function, you're done. You'll have no coverage. See, because you stepped outside of the scope of what your written agreement says. And the listing agreement clearly states you're not a property manager. Okay.
On the verification of the previous landlord, at another class I went to, they said, well, the present landlord's gonna give him a glowing report.
That's what I meant.
So that you get rid of them.
Well, that's what I made that comment.
Yeah, so check with the second one, the previous one, because they'll tell you more of the truth than the current one.
Yeah,
and that's for the seller.
The landlord needs to do that, yeah, the owner, and that is not uncommon. We find that, they can go back, but it was interesting on this one where we got sued, it was all forged. It was all fake, it was somebody else was setting up to do that, so, again, it was unfortunate because the listing agent thought they were doing an extra service, they were helping when they caused them to be in the middle of a horrible situation like that. So does anybody want to do leases this afternoon? No. Yes.
If a buyer has access performed during their option period, we don't notify the seller that they're doing or not?
Okay, this is great. She said the buyer performed a hydrostatic test without the seller's written permission.
What recourse does the seller have?
They go after the buyer, they'll sue. If the buyer's agent involved, they'll go after the buyer agent and buyer broker. Sue them all.
Oh my God.
You weren't a part of that, were you?
Oh, no.
Good.
No. I did have a buyer have that done, but we had the seller order it and pay for it.
Yeah, that's the way it would be before. Once they changed it and said we have to have written authorization from the seller, that threw me into a thing, well, okay, how does the seller provide it in writing? They can't do it by email because I could get into anybody's email and send an email out, that kind of thing. And so the test was that the attorney said, no, it needs to be an authorization form attached to the contract. And the thing is, last time when I talked about that change, we have a lot of buyer's agents who have not set the expectation correctly for the buyers. The buyers think they own that property and they can do anything they want, you know? And as a listing agent, you're gonna say to the buyer agent, oh, I'm so excited, I've just provided you notice that we have an acceptance of a contract, it's been executed with today's date, and I look forward to this. Please remember that prior to setting up any appointments and going, you must notify me the truck inspector, their name, who all's gonna be there. In other words, you as a listing agent have to have all of that secured in writing to the buyer agent so that the buyer agent doesn't think they can bring an entourage. Because have you ever had it where they brought everybody that they're related to? Yeah, see, I had a little minivan, and it was like, it was a magnet for grandma and grandpa and aunts and uncles. And I mean, there were some days when, you know, they would never get out of it. You know, they just thought I was some kind of tour guide who was showing them around the city and stuff like that. And I really freaked out because that was back in a time where people weren't suing for everything. And I would say, okay, here's how it works. All the little ones have to be attached to a big one. You know, and I said, we have to stay together. We're just gonna all be going in this herd. And I lived in South Africa. And I went on lots of safaris, and everything that could bite, sting, or eat me and kill me in 20 seconds was in that part of the world. And it's funny, when you see pack animals, I really felt this was great training for me to see all these on safaris and stuff, because that's what we were as realtors. You know, we've got our little pack, and we have to keep them together. And that is truly what you have to do when you are opening up somebody else's property and you're bringing in these people. And it's really hard. It's not an easy thing to do when you have an entourage. But just remember today, you're not going to bring anybody to the seller's property without the listing agent knowing. Okay? And if they fail to say no, that's their problem. Okay? But again, you are responsible. Trex interviewed the agents, and they said, did you have your eyes on your client at all times? And the agent, bless her heart, she's right there. She says, no, the husband left the master bedroom and went into this other room. And that's where they allege that that occurred.
And that happens every time.
Oh, it does. And that's what I'm saying. I was always very, you know, especially in occupied property, it was crazy how we just looked like this little herd and we weren't gonna let go of each other. I even had a hard time, I'll be real honest, when somebody would say, can we use their restroom? I'd go, no. I said, there's a Whataburger down the way, we'll go down there. Yeah. You know what I'm saying? Because with my luck, the toilet would overflow and flood the house. You know, there were just, you know how things can happen? You just have to kind of be more conscious of it today than I think we were 10 years ago, and especially over 20 years ago, like it was for me. But I was always very concerned because I didn't want anything to go wrong in the property of others. Yes?
If we can't look at this 10-2003 and see income, and how do we verify that a person can afford the lease?
Okay, is the tenant asking you, can I afford this lease?
No, they always can afford. When they call and they want to go out, they don't, it's not a problem for them. It becomes a problem for us because somewhere along the line we find out they can't afford it. So we're not supposed to ask those kind of questions anymore.
Well, I think what you would do is find out, let's look at what the landlord's rental criteria is, and there are some things that.
So we can provide them with the criteria, right?
Well, you are required to.
But we can't explain it.
Well, you're not gonna say that he wants 3 times this and he can't do that. Your explanation of it, yes, you can say, here's what the landlord's required, let's see if you match that requirement. Oh yeah, that you can do.
Well, how's she supposed to know?
You can't show the form.
I'm confused. I'm confused too. If you're not allowed to see their personal information.
Wait a minute, one at a time.
If you're not allowed to see their personal information, you're about to take them out, and they're anywhere from $800 to $1,800 a month.
You're not gonna see their credit report, no way.
No,
You're gonna ask them, what is your monthly income and your debts? What do you have that you can do this? The landlord for this property says it has to be at this point. Are you there?
Okay.
It's on them
But what if they say they are, and then you
They're
just
not.
go your
That's,
mind?
well, personally, I don't like it when people don't tell you the truth. But I can't prevent that.
That's
I can't
always.
prevent that. But you certainly can ask for the landlord's rental criteria, and that's what the landlord's rental criteria should be there. It'll say a minimum monthly income of this, blah, 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 and those other things. And so, you can certainly find out, and do your fact finding. It's like a next sheet that we give to a prospective buyer, saying this is what you're gonna need if you wanna buy this property at 3%, 3.5% down, or 10% down, or 20%.
So you can't just say pay stubs or anything else?
No, I would never ask to see their pay stubs or any of their confidential information. You can rely upon what they say to you. If they lie, unfortunately, there's nothing we can do.
Yeah, that form is signed by them, not by you.
Right, absolutely, yeah. So, as I said, the landlord determines the criteria. So just remember that you can say, here's my thumbnail of what we have been told. You need X number for, and there are formulas out there that you can see about what the criteria could be. But a landlord ultimately is the one who's gonna say, this is my criteria. I approve this. So, again, the biggest way that you ask a question if you're working with a new prospective tenant is you say, what are you currently paying?
That doesn't always work.
No, well, if they said, I'm currently paying $800 a month.
Well, I had a lady telling me she was paying $1,000, but when I found out exactly what she grossed, she couldn't afford that. And so when she was looking for another property, I couldn't go as high, I had to go no higher than 800.
Yeah, and that's, as I said, that's fine, because once you find out, when they tell you, you can rely upon it. Once you find out that they have not told you the truth, you can never rely upon what they say again. Okay, but that's what we've been told by Trek. We can rely upon them, but then once we are told something and we have found out it's not true, we can never rely upon that again.
But she's actually paying $1,000. Whatever contract she got in back then, that was their criteria. But if now the tenants will only want 3 times rent, she don't qualify.
Yep. Yeah. As I said, in each property, each property is gonna be different. Every landlord's gonna have different criteria.
But if it's one that says a requirement of 600 credit score, and then your client is telling you they have 580, would you go ahead and submit?
I would find out from the listing agent. The tenant has told me they have a 580 credit score. Will your landlord consider it? You don't proceed forward. If they don't make that criteria perfectly, you don't move forward. You would have to get them to accept that. Yeah. Yeah. All right, good people. Y'all have a great one.